Edward Lucas is so excited to file for his naturalization and become a United States citizen. Part of his excitement is that he will finally be able to petition his wife, from whom he has been separated for almost 8 years. Little did he know that the one lie of telling the immigration officer that he was single during his immigrant visa petition interview will cause a lot of pain and more years of separation from his wife. Confused and depressed, he decided to look for answers as to how he can straighten his twisted fate.
Desperation makes people do strange things. An adult beneficiary of a petition filed by a U.S. permanent resident parent usually has to wait many years before receiving his visa. If he marries before receiving his green card, his petition becomes invalid and he loses his chance to come to the U.S. Yet it's hard to put life on hold for 10 or more years. Some people facing this situation marry and have children. Years later, when informed that their petition is now ready, find it impossible to give up that dream of coming to America. An alien in this position sometimes lies to the U.S. Consulate about their marital status and the existence or legitimacy of any children, and gets a green card as a single daughter or son of a permanent resident. In a few minutes, attorney Jeremiah Johnson, a partner at Reeves Associates, will tell us how Reeves Associates have helped many immigrants correct past misrepresentations and reunite with their families. I understand that Reeves Associates have helped many immigrants in the past help be reunited with their families when they've been caught in a lie or a fraud.
The way we do it is basically by a waiver, okay? And so you can waive a lie or misrepresentation or fraud, but you can only do it in immigration court or with the immigration service.
Did you know? Immigration and Nationality Act Section 237A1H shows an alien who lied to obtain a green card to apply for a waiver. The waiver is available to aliens who are the spouse, parent, son, or daughter of a citizen of the United States, or of an alien lawfully admitted for permanent residence. In order to receive the waiver, the alien must show the positive factors in his case outweigh the negative ones. Positive factors to be considered may include family ties in the United States, residence of a long duration in this country, particularly where it commenced when the alien was young, evidence of hardship to the alien or her family if deportation occurs, a stable employment history, the existence of property or business ties, evidence of value and service to the community, and other evidence of the alien's good character. Evidence of the positive factors must be carefully presented to the court through documentation and testimony. In addition, the negative factors must be thoroughly dealt with and explained. Because so much is at stake, aliens in this situation should seek the advice and assistance of an immigration attorney who is experienced in this type of case. Attorney Jeremiah Johnson is the managing attorney of Reeves Associates' San Francisco office. Mr. Johnson joined R&A early in 2005 and became a partner of the firm in 2008. Prior to joining R&A, he served as an immigration attorney for 2 years. Mr. Johnson is a contributing writer to R&A's internationally recognized immigration column and lectures on various immigration topics. Mr. Johnson has broad experience representing hundreds of clients in matters before the United States Citizenship and Immigration Services, or USCIS, the Immigration Courts, Board of Immigration Appeals, and the federal courts. Specifically, he has extensive experience in reuniting families through family-based immigration, consular processing, naturalization, non-immigrant and immigrant visas obtained through employment. In addition, Mr. Johnson also represents clients in the federal courts to compel USCIS to adjudicate cases that have been unreasonably delayed or cases that have been wrongfully denied. Throughout his career, Mr. Johnson has tirelessly pursued justice on behalf of others. In addition to his role as an immigration attorney, He has been active with the International Rescue Committee, the Center for Law and Global Justice in Cambodia, the United Nations Commission on the Status of Women, the United Nations Commission on Sustainable Development, and the United Nations Committee on the Elimination of Racial Discrimination. Jeremiah Johnson obtained his bachelor degree from Randolph-Macon College in 1996. He graduated from the University of San Francisco School of Law in 2003 and has been practicing immigration law since graduation. He was admitted to the California State Bar in 2003. He is also admitted to the U.S. Court of Appeals for the Ninth Circuit, U.S. Court of Appeals for the Fourth Circuit, U.S. District Court for the Northern District of California, and U.S. District Court for the Central District of California. He is a member of the American Immigration Lawyers Association, the National Immigration Project of the National Lawyers Guild, and serves on the Board of Directors for Human Rights Advocates. Mr. Johnson also serves as a pro bono asylum mentor for the Lawyers Committee for Civil Rights.
Okay, let's say I'm caught in a lie or a fraud. What are the type of consequences that could happen to me or my family?
Well, one thing is that it can deny your U.S. citizenship application. So if they know about the fraud, they may say, no, you can't become a U.S. citizen. The other thing is that you may have petitioned your family. As an immigrant, you can petition your spouse and children. But if the embassy or the immigration service finds out about that previous fraud, they're going to deny the visa and refuse to issue that visa to you. So you're going to be separated from your family, stuck in a sort of legal limbo.